A quorum is present, and the Subcommittee on Social Services will come to order. Members of that committee will cast a vote for attendance. Clerk, open the roll. Okay, we have a quorum. All right, we don't have any administrative announcements, so we will start with our hearing. I will ask Delegate Watts to come to the podium, please.
Thank you very much, Madam Chairman, for the courtesy. Speaking to House Bill 747, I would like to make a brief statement and then request that it be carried over. And the reason for the brief statement is this has to do with open captioning offerings of movies as they are available. There's good negotiation going on between theater owners and the community who needs hearing assistance. However, there is also a major study going on with the national organizations representing those who need hearing assistance. And that depends upon an Ernst & Young study that is coming out this spring. I really believe that we will be able to have a good bill before the body next year. So I appreciate the courtesy of carrying over 747 and allow me to mark that progress of good faith.
All right. That motion has been properly moved and seconded. House Bill 747 from Delegate Watts will be, it's all those in favor say yay or aye. Those against it, nay. The bill has been carried over. Thank you,
Madam
Delegate
Chairman.
Watts.
Thank you, members of the committee.
Delegate Carey.
Good morning, Madam Chair and members of the committee. I'm here on HB 1006. This is actually a recommendation of the Virginia State Crime Commission. The bill accomplishes two measures, and it amends the existing sex trafficking assessment to human trafficking and grants social service departments the same authority to interview a child victim as they have under current law when conducting investigations and family assessments. So just a little bit of background. Last year, we passed a bill allowing for a sex trafficking assessment, and that was, again, part of the Crime Commission's efforts. The sex trafficking assessment provides social service departments with a mechanism to intervene when a child is being sex trafficked. This human trafficking assessment will provide social service departments with the authority to intervene in both sex and labor trafficking cases. Under current law, the Department of Social Services does have the ability to interview a child victim without the presence of a parent or guardian. This bill then will now allow for that same interview to happen in cases of human trafficking. That's the bill.
Thank you, Delegate Herring. Any questions to the patron from members of the committee? Okay, being none, is there anyone in the audience in support of this bill? Are there anyone in the audience in opposition of this bill? Okay, being none, this subcommittee works in motions. Okay, the bill has properly been moved to report with a second. Clerk, open the rolls. Members, cast your votes. The bill is reported 6-0 to full committee. Thank you, Delegate Herring.
Thank you.
I have a request. I believe that Delegate Askew is already gone. Okay. So. Delegate Askew? Yes. He has to cast a vote. I understand another subcommittee, so we're going to help him first.
Good morning, Madam Chair, members of the committee. I'm here to present HB 799. It's a bill that implements testing in child day programs for lead, requires licensed child day programs and certain other programs that serve preschool-aged children to develop and implement a plan to test potable water from sources identified by the U.S. Environmental Protection Agency as a high priority. The bill requires such plan and the results of each plan, each such test to be submitted to and reviewed by the Commissioner of Social Services and the Department of Health, Office of Drinking Water. The bill stipulates that if the results of any such test indicate a lead level in potable water that is above 15 ppb, that the program shall remediate levels of lead to below the 15 ppb. And if the school does not choose to test the water, they can use other sources such as bottled water or coolers.
Thank you, Delegate Askew. Are there any questions from the committee members to the patron? Sure.
Is there currently a testing program for this? Is this an add-on to the current testing program?
There is not a current testing program.
For any potable water whatsoever? Whether
I do not believe so, no, sir.
Thank you.
Any other member have a question? Delegate Tran.
Thank you, Madam Chair. It's just some questions for the patron. I wholeheartedly support the intent and making sure that our water that our children are drinking in their early ages in a daycare or preschool is of high quality. But I was just wanting some clarification on how this would happen in on the ground in implementation, and some clarifying questions. I don't know, Delegate, if you or if somebody who's with you today in the audience maybe could be able to answer them. So could you just clarify if this is this also affects in-home daycare facilities?
Madam Chair, speaking to the question, it does affect in-home daycare facilities.
Follow-up, Madam Chair. Are these tests that a daycare facility owner would be able to conduct themselves? Are the kits easy to purchase? Are they? Do you know how much they cost? And then my last question would be, I imagine there are thousands of individual in-home and other daycare facilities across Virginia. And would the Commissioner and Department of Health, are they situated properly to accept individual results from thousands of facilities?
Madam Chair, to answer the first question, because this problem really arose and really was brought to my attention via the K-12 bill that I have is very similar to this. Goes a little bit farther that I hopefully present later this week in another education committee. But they stipulated when they did some testing in Virginia Public Schools that it was about $3,000 per school to test, and I believe it was done by an outside organization. So I believe it would be about probably, I'm just sort of guessing with this answer, but more than likely less than $3,000 because I don't believe any smaller facility that's less than K-12, that's pre-K, would be as large as the elementary school or a high school. To answer the second question, I would have to get back to you on that. I don't know how much capacity they have at the time to do that. Yes, I appreciate it.
Madam Chair.
Delegate Air.
So just a follow-up question on Delegate Tran's question. Is there someone here from the Commissioner's Office or the Department of Health that could speak to whether or not the cost for an increased level of testing is a cost they are prepared to absorb?
Madam Chair, I have Mr. Dwayne Roadcap here to speak on the bill.
Thank you. Oh, Madam Chair.
Delegate Air.
Sir, good morning.
Hi, I'm Dwayne Roadcap with the Office of Drinking Water, Virginia Department of Health. I think one question was, how much would the test cost? You can have the lead sampling done at any lab for about $35 to $40. And with regard to your second question, we would be anticipating a fiscal impact. This bill has is identical to Senate Bill 393, and that was referred to Senate Finance earlier this week.
Okay.
On that question, and there's a similar bill from the 2018 session. I think it's Senate Bill 1622 or 1629, and there's an FIS associated with from the last year's General Assembly session associated with this language.
Thank you.
Are there any more questions from members of the committee? Being none, are there anyone in the audience to speak in favor of this bill?
Madam Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children. We support this bill, and I did want to clarify that it's licensed daycare settings.
Thank you. Are there anybody else in favor of this bill? Is there anyone in the audience in opposition of this bill? Okay, being none, this subcommittee works in motions.
Madam Chair, I move to report and refer House Bill 799 to appropriations.
House Bill 799 has been moved to be report and referred to appropriations and properly seconded. Clerk, open the rolls. Members, cast your vote. House Bill 799 has been reported 6-0 to refer to appropriations. Delegate. Thank you, Delegate Askey.
Thank you, Madam Chair, members of the committee.
Delegate Scott.
Good morning. Good morning, Madam Chair and members of the committee. Madam Chair, I trying to reach out to you. I think we have the same and/or similar bill, and I was wondering if you'd be willing, and I have an amendment to my bill to add TANF to it. I think the staff has it.
Delegate Scott, we have about 5 different bills.
All related to the same
all
thing.
related to the same issue. So why don't you present your bill? If you want to move the amendment, we move the amendment.
I want to move
We're
the
going to
amendment.
roll them into one bill.
Okay. Thank
Thank
you.
you.
I would move the amendment.
So I will need the motion to adopt amendment.
So moved.
Okay. There's a substitute for Scott. That's Scott. Okay, sorry. There's actually a substitute. So can I have a motion to move the substitute?
Adopt the substitute.
Okay. All those in favor? The substitute has been presented and properly seconded. Okay. Could you explain to us what it does, Delegate Scott?
What this bill does is
Just a substitute.
Oh, the substitute. The
Yes.
substitute just adds in TANF. It only had food stamps, FSET or SNAP. I guess it's SNAP. The SNAP, the Supplemental Nutritional Assistance Program information in, and this adds the Temporary Assistance to Needy Families program in as well. That's it.
Thank you, Delegate Scott. All those in the substitutes have been reported and seconded. All those in favor? Aye. Against it? All right, Delegate Scott.
So what this bill does is right now, if you are have been convicted of a drug crime, you are ineligible for food stamps and ineligible for TANF assistance, which affects a lot of women a lot of folks who are returning home and trying to get, and you know, the biggest barriers to reentry, there's a big emphasis on reentry, but if you can't eat and you can't find a place to live, it's difficult to have a firm footing. So what this does is remove that barrier, along with the other 40 or some odd states that have also removed this barrier for folks to be able to be eligible for Supplemental Nutritional Assistance Program, the Food Stamp Program as we know it, and TANF, which is the Temporary Assistance to Needy Families Act, which is folks who need cash assistance. Normally, they have to have children, minor children, dependents to be eligible for cash assistance. So what this does is remove that barrier for those folks. The City of Portsmouth, we have some staff here from the city who are support who may speak on this, but this bill will remove that barrier. This would provide the public benefit of reducing recidivism by giving folks the opportunity to have Maslow's theory is you need food and shelter first before you can have self-actualization. So this will give folks the opportunity to start over and begin to put their lives back together. As you may or may not notice, but this ban is now having a disproportionate impact on women and children. Preventing them from being able to have healthy nutrition. And so what I'm asking you to do, 41 states since '96 have already opted out of this ban, and I'm just asking this committee to adopt this bill. Thank you.
Are there any questions to Delegate Scott from members of the committee? Okay, Delegate Scott, we have similar bills on these issues, so we are going to call the other patron who's present to talk about this bill, and then we'll call people in favor and opposition, so we just...
All right, thank you, Madam Chair.
Thank you, Delegate Scott. Delegate Lopez.
Thank you, Madam Chair. I am so happy that this day is coming because after working on this for 5 years with the Virginia Poverty Law Center and several activists and people affected around the state, that we are in a good posture. As you guys know, in 1996, Congress enacted welfare reforms designed to promote work by welfare recipients. At the same time, it provided for temporary assistance for needy family block grants to states for temporary financial assistance necessary to provide family support. It also provided food stamp or supplemental nutritional assistance program benefits for families at that time. However, the federal law provided that these SNAP and TANF benefits were not be available to ex-offenders convicted of drug felonies unless the state opts out of this ban. HB 1130 would finally opt Virginia out of those bans. The bill provides that a person who is otherwise eligible to receive TANF shall not be denied assistance solely because he has been convicted of a drug-related felony. The bill also states that a person shall not be denied food stamp or SNAP benefits solely because she has been convicted of a drug felony. Here are the facts. 91% of those folks recently released from prison don't have reliable access to food. It costs the state more money to imprison folks than it would cost to provide these public benefits, especially since these benefits are federally funded. Bless you. These bans disproportionately affect women and children and people of color. Women and children make up the majority of public benefit recipients, while people of color are more likely to be imprisoned for drug felonies and live in poverty. Repealing the bans will provide access to important employment training programs and opportunities through the SNAP and TANF programs. Virginia needs to end the lifetime bans on SNAP and TANF for two major reasons. One, they unfairly punish the families of ex-offenders. Parents re-entering their communities after incarceration routinely require public benefits to reunite their families, pay rent, buy food and clothing, and other necessities. And denying access to families as they attempt to rebuild their lives is counterproductive. Family members and children, especially children who are innocent of any wrongdoing, are being punished for the crime of a parent. Two, they hinder the individual's successful reentry into society upon release. By strengthening families and providing transitional assistance, the opting out supports the goals of successful reentry and decreased recidivism, which can thereby diminish the burden to taxpayers by reducing the $21,300 annual cost of incarceration per inmate. For this reason, Governor McDonnell's Offender Reentry Council recommended enactment of this opt-out program reform. Former Governor McDonnell himself as a delegate, patroned this reform in 2005. The purpose of this bill is to promote public safety by allowing positive reintegration of ex-offenders, reduce the burden placed on family members and local communities, and increase the chances of gainful employment for ex-offenders, which decreases the likelihood of recidivism. Many states have already taken this action for TANF benefits, and Virginia has already done so with conditions for other key federal benefits such as SNAP. We need to lift those conditions. In fact, last point, since 1996, over 40 states and the District of Columbia have repealed or modified the bans, including Texas and Alabama in 2015, Georgia and Alaska in 2016, Louisiana in 2017, Indiana in 2018, and West Virginia and Mississippi in 2019. All incredibly liberal states. Simply put, justice is being denied to returning citizens who have served their time, but face a life sentence from receiving public benefits due to drug felony on their record. And most importantly, we're talking about a very small amount of money relative to the current non-general fund federal surplus that we have for TANF. And most importantly, even more than that, we're talking about a few hundred kids who could have a little bit more money to buy a warm coat in the wintertime, shoes, and maybe help pay for mortgages and rent. I think it's the duty of this General Assembly to pass this bill finally. Thank you, Madam Chair.
Thank you, Delegate Lopez. I believe you had a substitute.
I did. A substitute that I provided to council.
It's, I can hand it out if you'd like, or I can explain that it is very similar to the one we just received on 391. The only difference is that Delegate Lopez's substitute, instead of including the language, has been convicted of a felony offense of possession of a controlled substance in violation of 18.2250. Provides for eligibility for individuals who have been convicted of a drug-related felony. So
Right, and so the point there, Madam Chair, is that we want to make it as all-encompassing as possible, so it's not just drug possession. We want it to be exactly like Mamie Locke's, Senator Mamie Locke's legislation on the Senate side, which is what I believe you want as well, Madam Chair. Madam Chair, isn't that correct? You want, Madam Chair, if I can just pose a question, I believe you want as well that we have this to be as expansive as possible, not to be limited to drug felony possession, but to all drug-related felonies, correct?
That's correct.
And so I would hope that you would accept this language, which was identical to Senator Mamie Locke's language, as the vehicle for whatever you decide to do.
Delegate Lopez, I will tell you that there was a bill that is already a mirror to Delegate Locke.
Did you accept this
bill.
one? Did you accept this?
We will tell you after, so for now, we're going to present the bills.
All right, thank you.
Okay, that substitute has been moved and seconded. So next we'll hear House Bill 566, which is mine. Madam Chair, members of the committee, I would like to move a substitute. I would like to present a substitute to you.
I'll entertain a motion for the substitute. It's been moved and properly seconded to report the substitute. All those in favor? Aye. Opposed? The substitute is before us.
Thank you, Madam Chair. I present to you House Bill 566 with a substitute. As it was mentioned before, I will try to address number one, Delegate Lopez's questions about a person, whether this bill includes it's a person will be convicted of a drug-related felony, and it does. And I would like to add this just that the bill ensures that drug crime convicted felons can get a SNAP and TANF after being released from prison to help their new lives. There's about 500,000 people in the U.S. that are incarcerated on low-level drug crimes. Most states will give food stamps or some form of aid to people that do rehab programs, but TANF is only given in 11 states, and Virginia has been failing for so many years. We have models like Arizona, Colorado, Massachusetts. Arizona does food stamps and eligibility after conviction for drug testing rules. Individuals needs to be in a drug treatment program to prove this. So this bill is asking to provide TANF, a TANF recipient, to expand these benefits to these individuals for TANF and food stamps. Most of these TANF recipients are victims of domestic violence abuse, and they have been prevented to get these benefits. The exemptions are, I think it's something that we should consider, and I hope it's the will of this body to pass this bill.
Thank you, Delegate Guzman. Questions from the committee?
Yes, Madam Chair. So, Delegate Guzman, if I understand the difference in part of your language and Delegate Lopez is that Delegate Lopez has in here federal offense, and yours does not indicate any, whether misdemeanor or federal. It just says drug-related. I take that back.
I believe staff has a response.
Yes.
I'm sorry, so we didn't distribute the paper copy of Delegate Lopez's substitute. I'll hand you a copy now. It would make it identical to the Senate Bill 124. The language of that substitute, so the language of the substitute we adopted to Delegate Lopez's bill would make clear that benefits will be provided, shall not be denied to a person solely because that person has been convicted of a drug-related felony. That substitute pulls in the language that makes it identical to this substitute to 566, which uses that language. On line 15 of the substitute to 566, where it states, shall not be denied assistance solely because he has been convicted of a drug-related felony. That language is mirrored on lines 23 and 24 of the substitute to 566, so they are both addressing individuals convicted of a drug-related felony.
Thank you.
Further questions from the committee? Okay, at this time, is there anyone in the audience to speak in favor of House Bill 566? And if you are also in favor of the others, you should speak at this time as well.
Good morning, Madam Chair.
Good morning.
My name is Carl Phillips. I'm a veteran, and I have a drug felony on record. I'm here to support this bill because I've paid my debts and I've, reformed myself. And it's harder to blend back into society without, food. And this makes it, this bill will make it better and easier for people like me to blend back into society and be healthy as well and make it a little bit easier for us. We've already paid our debts, and we just want a chance to be that gracefully, blend our way back into society like a regular, normal person. And I support it, and I thank you for taking the time to listen to me. I thank you all for that.
Thank you.
Good morning, Madam Chair, members of the committee. My name is Sherry Neal. I am the Intergovernmental Affairs Manager for the City of Portsmouth, Virginia. And we thank Delegate Scott for bringing this forward again. Some of you who were here last year could remember we fought this battle tooth and nail last year. Made some headway, more headway than had been made in years, but unfortunately it didn't get through. Just a quick little background for myself. Prior to my working for the City of Portsmouth, I was the Chief of Staff for Senator Maxwell, who served in this body up until 2003. And during my term with Senator Maxwell, we fought very hard to deal with the extreme consequences of the collateral consequences of criminal arrests and convictions in Virginia, to try to take some of this pressure off of the people who are trying to get back into society after making whatever errors they made. The Commonwealth has made great strides since that time in dealing with recidivism, and this would be another step in that direction. So we really hope that you will pass this bill through and let it go forward. Thank you very much for your time.
Thank you.
Good morning, Madam Chair, members of the subcommittee. My name is Salam Bhatti from the Virginia Poverty Law Center. For 24 years, this law has festered in our state, sabotaging the efforts of thousands of low-income Virginia neighbors from successfully reentering society and paralyzing them from these amazing benefits that can help them out of poverty. It has increased their chances of recidivism. Studies conclusively show that opening public benefits up to returning citizens who have drug felonies on their records decreases their chances of recidivism and increases their opportunity for a better life. With this law that we've had for 24 years, our low-income Virginia neighbors came to us hungry, and we did not feed them, naked, and we did not clothe them, unemployed, and we did not employ them. By pressing yes and voting for this bill, we will give them comfort in knowing where their next meal is coming from, solace in the ability to afford some necessities, and confidence as they are able to enter some workforce programs that were previously blocked to them. We thank Delegate Lopez and all the other delegates for presenting this bill, and we fought tooth and nail with Delegate Lopez for the past few years on this, and we are so excited to see the enthusiasm from everybody in introducing this bill separately. So we do hope it is the will of the subcommittee to vote for this bill and move this forward. Thank you very much.
Thank you.
Madam Chairman, members of the subcommittee, Becky Bowers, I'm here representing the Substance Use Addiction Recovery Alliance. I could never begin to be as eloquent as the past three speakers. I will tell you that our members have been also advocating and pushing for this because many of them have been impacted by the vicious cycle that has been created when they have a drug felony in their record and are in recovery and trying to be productive citizens. So I hope that we would support all of these bills.
Thank you. Anyone in the audience in opposition to the bill? Thank you. At this time, I believe we need to roll the House bills that came before this one, House Bill 1130, House Bill 391, into House Bill 566. Oh, and there are two others.
Yes, there were a total of 5 bills on this topic. We had House Bill 391, Delegate Scott's bill. That bill was identical to House Bill 786, Delegate Bagby's bill. We also had House Bill 1130, which in its original form was identical to House Bill 814, which is Delegate Ward's bill. So there are 2 pairs.
I will accept a motion at this time to roll those bills. It's a voice vote. All those in favor, please state aye. Aye. Any opposed? Now that we have the final vehicle, House Bill 566, this bill does need to go to the Appropriations Committee, and I will accept a motion as such. So moved. Second. It's been moved and properly seconded. All those in favor, please vote yes on the voting board. The motion carries 6-0. Thank you, Delegate Guzman.
Thank you.
Delegate Carol Fott.
Thank you. Good morning, Madam Chair and members of the subcommittee. I'm here to present my bill, House Bill 933, Kinship Guardianship Assistance Program. First, I would like to move an amendment in the form of a substitute.
Delegate Carol Foy, could you explain to us what the substitute does, please?
Absolutely. Madam Chair, the substitute is a recommendation by the Supreme Court of Virginia. What the substitute does is that it adds two code sections, 16.1-282.1 and 63.2-906. What those two code sections does is that they add the language that placement with a fictive kin is an acceptable permanency goal. In Virginia, the goal of foster care is permanency and placement with relatives. What this bill does is expanding the definition of kinship to fictive kin, which are godparents, people who are in the community who, like someone who's like your church member, a close family member. So it expands the definition of kinship. But we have to align that with the goal of foster care, which is permanency.
Do I have a motion?
I move to adopt the substitute.
Okay, the substitute have been moved and properly seconded. All those in favor, say aye. Anyone against it? All right, the substitute has been taken.
Thank you,
Delegate Carol Foy.
Thank you, Madam Chair. So the problem in Virginia is that we have one of the highest rates of children aging out of the foster care in the country. So once we get our children into the system, they stay there. And the statistics are overwhelmingly high for drug use, teen pregnancy, unemployment. And so the goal should always be for us to find ways to get our children placed with permanent forever families. One way to do that is to place children with kinship care. And so kinship is usually relative placement because trauma is lessened when a child is placed with someone who they know. However, we need to expand the definition of kinship so that way we can have more children that have more accessibility to be placed with more people who want to care for them. And so the reason we need to do that under this bill is because it's very difficult, even if a person wants to open up their home, to go from a fixed income family of 2 to a family of 5. So if we can give them the financial assistance that's available under KinGap by making the fictive family eligible, that's exactly what we want to do. So what this bill does is that it expands the definition of relative to include fictive kin, which are godparents, a church member, a close family member, thereby opening up a larger population that can take advantage of KinGap. KinGap provides financial support to kinship care providers that meets children's needs, creating more options for permanency and stability for older youth in foster care when adoption is not feasible. Our hardest to place population are older foster children and children of color. In addition, this bill corrects the definition of foster home to reflect that a foster home is a residence that is approved by a child placement agency, not licensed by a child placement agency. So this bill is highly recommended by Virginia fosters, community members who would qualify as fictive kin, Department of Social Services, and Deputy Secretary of Health and Human Resources, and Division of Family Services. So I'm open to answer any questions anyone has.
Do I have any questions from the committee members to the patron? Okay, being none, we have an identical bill from Delegate Brewer. So what we're going to do at this point is, thank you, Delegate Carol Foy. We are going to listen to Delegate Brewer, and then we'll open it to the audience.
Thank you, Madam Chairman, members of the committee. Delegate Carol Foy said probably everything I was going to say. This was brought to us, I'm actually the Vice Chair of the Commission on Youth. This was brought to us this year as one of the many recommendations we were set forth to put out to work on in regards to KinGap and working obviously towards ultimate permanency. I did go ahead and file a budget amendment on this bill just in case. We still have not received back to FIS. I do understand that DSS should be able to absorb, and it looks like it may be under 50,000. We had estimated 73, so just for safekeeping, I went in and filed that budget amendment.
Thank you, Delegate Brewer. We understand that we have to refer this bill to appropriations. Just so the public is clear, because this is the second time that is brought up to the attention, I would appreciate the patrons, when they have duplicate bills, not to wait to the date of the hearing to make decisions on which will be the vehicle. This subcommittee meets during the week to appropriate the agenda items for this hearing. So I would ask the patrons in the future, if you want duplicate vehicles, to reach out to the chair or the subcommittee members of this committee and have these conversations in the past, so don't put the members of this committee in an uncomfortable position. For now, I would like to invite the individuals who are in favor of this bill.
Madam Chair, members of the subcommittee, I'm Duke Storn, Commissioner of the Department of Social Services, and the administration is in strong support of this bill. Thank you very much.
Madam Chair, Todd Gackey with the Family Foundation. We support this bill. Also, as a foster care parent, this is a great way to provide loving homes to especially those who are prepared to phase out of the foster care system. So we recommend this committee support this bill.
Madam Chair, members of the committee, James Pickrell with the Virginia League of Social Services Executives. We'd like to thank Delegate Carol Foy and Delegate Brewer for bringing this bill, and we are also strongly in support. Thank you.
Madam Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children, and we too are strongly supportive of this bill.
Madam Chair, Valerie LaRue from Virginia Poverty Law Center, and we also support this bill. Thank you.
Madam Chair, Cassie Cunningham with Children's Home Society. We also support the bill.
Thank you. Is there anyone in opposition of this bill?
Madam Chair, I move to report and refer House Bill 933 to, do we have to move? First, I move to roll House Bill 917 into House Bill 933.
All right, this bill has been, all those in favor will say aye.
I now move to report and refer House Bill 933 to appropriations.
All right, this House Bill 933, that will we will include 917 as part of 933, has been properly moved to be report and referred to appropriations. No, you're fine. Sorry about that, because, but now, clerk, open the rolls. Members, cast your vote. Okay, House Bill 933, which includes Delegate Brewers as well, has been reported and referred to appropriations 6-0. Delegate Brewer, you have another bill.
Madam Chairman, members of the committee, House Bill 920 creates a state-funded kinship guardianship assistance program modeled after the federal program currently in place in Virginia. State KinGAP would allow an additional permanency option for children not eligible for the federal program. The Commission on Youth heard from many social service and local departments during its foster care study this past year. And they found that the current federal KinGAP has eligibility requirements imposed by the federal government that are just too rigid and prevent wider use. House Bill 920 would ensure the state program helps the children and families who will be best served by kinship guardianship. It will be the pleasure of this committee to report the bill, the goal of bettering the lives of our children.
Delegate Brewer, do you have any amendments to this bill, or is just in
No
its
amendments
origin
to this
form?
bill.
All right. No. Sorry about that. Do we have any questions for Delegate Brewer, members of the committee? Being none, is there anyone in the audience in support of, sorry, yes?
Madam Chair, I think we may have.
Sidebar real quick.
We think there might be a
Okay.
Can we do a sidebar real quick?
Oh.
Might want to move on to do one more bill, and then we'll come back to this one.
Going to East.
Okay, go to East.
This committee is going to East. Delegate Brewer.
Thank you, Madam Chair. We actually do have a couple of technical amendments, and we do have a substitute before the committee. And those are coming through on lines 29 through 31 and in lines 52 through 54. And it's just to clarify a little bit of issue on permanency and also a little conversation about reunification.
Move to adopt the substitute.
All right, the substitute has been moved and properly seconded. Is there anything additional that you would like to share, Delegate Brewer?
No, Madam Chair.
All right. Do we have any questions for Delegate Brewer? None. Please, those in favor of the bill, come up front.
Madam Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children, we support this bill.
Madam Chair, Cassie Cunningham with Children's Home Society. We also support this bill.
Madam Chair and members of the committee, Valerie LaRue from Virginia Poverty Law Center, we support this bill.
Madam Chair, members of the committee, Todd Gackey with the Family Foundation, we support the bill.
Good morning, Rebecca Ricardo, Executive Director for C2 Adopt, and we support this bill.
Madam Chair, members of the committee, James Pickrell, Virginia League of Social Services Executives, and we also support the bill. Thank you.
Is there anyone in the audience in opposition of this bill? All right.
Madam
Being
Chair,
none-
move to report and refer 920 to the Appropriations Committee.
All right. The bill has been properly moved and seconded to refer House Bill 920 to appropriations. Clerk, open the rolls. Members, cast your votes. Okay, the bill has been reported 6-0 to appropriations. Thank you, Delegate Brewer.
Thank you, Madam Chair, members of the committee.
Delegate Levin.
Thank you, Madam Chair, members of the subcommittee. First, I have an amendment in the nature of substitute.
Move to adopt the amendment in the nature of a substitute.
Delegate Levy, if you can tell us only what the substitute does and the difference in between the bill and the substitute.
I'd be happy to, Madam Chair. The substitute is technical in nature. The original bill bans discrimination by localities, and the substitute makes clear that the localities get the funds from the state.
Thank you, Delegate Levine. You can tell us about your bill now. Thank you.
So HB 1051 repeals a bill that was put in the Virginia Code in 2012 to make Virginia the second state in the United States to fund taxpayer discrimination in adoption. That had never been in the code before 2012. Since that time, there have been a few other states that have also adopted similar bills, states like Alabama, Mississippi, South Carolina, Texas. What this provision does is it repeals that and says that you can't discriminate with taxpayer funds on adoption agencies. If organizations want to discriminate and they don't get taxpayer funds, that's their business. This only relates to taxpayer funds. The problem with this, the current code, is it harms children. There is no lacking of non-discriminatory adoption agencies. There are lots of non-discriminatory adoption agencies. These kids can be easily taken care of. In fact, the vast majority of faith-based organizations do not discriminate. The vast majority of them want to put the child with the best family. There are a few of them that do discriminate, and when that happens, it harms the child. I'd like to send and actually I've given, I think, a couple out. If at the page or someone could distribute. I think to the right side of the committee. According to DSS, not a single charity in Virginia since this law was adopted in 2012 has invoked this clause to discriminate. And I only know of one taxpayer-funded group in Virginia that chooses to discriminate, and that's the Commonwealth Catholic Charities. They take between 1 and 2% of all adoptions in Virginia. It's gone down from 61 to 59 out of 3,185. So it's between 1 and 2% of kids, between 1 and 2% of funding. There is easily enough non-discriminatory groups that will take care of those kids if Catholic Charities decides not to continue. Now, Catholic Charities continued from 1947 without this clause that was put in 2012. I don't know whether they'll leave or they won't, but if they do, there's lots of agencies ready to take up the burden. And I want to focus on the harm to the children, because that is what's being caused by the current law. So in South Carolina, for example, they have this clause, and a child was placed with a Christian agency, and a Jewish family wanted to adopt the child. And the Christian agency said, no, we'll keep the kid in foster care. Let the kid sit in foster care a while longer. We will not give the child to a Jewish family. There are other examples where, for example, you have a gay uncle or a lesbian grandparent, and they say, we'll take the child. And the agency said, no, we'll keep the kid in foster care. We won't let you go to your grandmother. We won't let you go to your uncle because we don't allow that to happen with our agency. There are other examples. Maybe there's a gay child, and the child would like to be with a family that respects that child's sexual orientation, and not with a family that, for example, would support conversion therapy. We all know that gay children going through conversion therapy, there's a very, very high rate of suicide. So this is for the child to go with a family that loves them and accepts them. Another example would be a child with serious medical needs that could be taken care of by a family that has a nurse in it, but not if that nurse is gay. So what happens is these laws require kids to stay in foster families longer. And you know, I was listening to Delegate Carol Foy. Kids don't want to be in foster families. They want to be in loving adoptive families. And we have lots of loving adoptive families ready to take these children. And the only thing standing in their way is these taxpayer-funded discriminatory organizations, keeping these children from finding the loving home that will take care of them. What's interesting is if you look at the children that are difficult to adopt, they tend to be the children that are older. Lots of families want to adopt babies. A lot of families do not want to adopt kids with special needs, kids that reach a certain age, sometimes children of color. Interestingly, in Massachusetts, they found that for the more difficult to adopt kids, gay families were the ones more willing to adopt them. Between 15 and 30% of the older kids in foster care were taken by gay families. So again, the choice is whether the child stays in foster care or gets an adoptive family. And in fact, there's a legal brief in the Third Circuit Court of Appeals followed by 17 attorney generals and D.C., including the attorney generals of Iowa, Maine, and Minnesota, arguing that these clauses harm children. And in the brief, they state, quote, in our experience, these decisions to repeal these laws, and again, these laws are very new. They've only existed in Virginia since 2012. Repealing these laws has not harmed either children in state custody or state and local government's ability to administer child welfare systems. We have enough agencies willing to take these kids. Again, it's not the child's fault where they go. To say that a child can't give a loving family because some agency wants to discriminate, we shouldn't harm the child for that reason. The child should get the very best family. We want agencies that look out for the best interests of the children. The two things that I passed out to you, the first is from Commonwealth Catholic Charities. These are statistics from DSS to show that it's a very small number of kids in Virginia. It is less than 2%. It's about 59 children easily replaced by the non-discriminatory agencies. And the other thing that I passed out was a statistic showing that before 2012, kids waiting for adoption was going less and less and less. And then this bill passed, and while we can't say that it's entirely a cause of this bill, now more kids are waiting for adoptive families. So we have families wanting to adopt, we have children wanting those adoptions. The only folks standing in the way are these taxpayer-funded discriminatory agencies, when there are lots of wonderful agencies that don't discriminate, that can take these funds and take care of these children. I have lots of folks who want to speak in favor of this bill. I do urge passage. Thank you.
Thank you, Delegate Levine. You are definitely very passionate about this issue. We could tell. Thank you for that. Are there any questions from the committee members to the patron? Delegate Trump.
Thank you, Madam Chair. Good morning, Delegate. Madam Chair, I have some questions for the delegate to help me better understand the substitute. Is that okay?
Sure. Delegate Trump.
Thank you. Delegate Levine, so I think in the substitute line 92 says no state pool funds and shall be provided directly or indirectly to any child placing agency. Could you or somebody from DSS help me understand what the term state pool funds means? And then also, what is the scope of child placing agency? I know we're talking about adoption and foster care, but are there other types of services that would also qualify kind of in that bucket? Thank you.
That's a wonderful question, Delegate Tran, and I have someone from DSS to answer that question.
Good morning, Madam Chair, and Delegate Tran, to your point and to your question is the original bill that was in front of you was strictly limited to only state funds. And so whenever in visiting with Delegate Levine about what he was intending from that end of it, Virginia has a very unique system that has our federal funds that sit inside of the department and our state funds that sit inside of the Office of Children's Services. And those are otherwise known as state pool funds. And so whenever you're talking about the state foster care system, is we separate it out based on two different agencies, whether it's federal funding or it's state funding. So the amendment that you see in front of you actually widens the initial bill that you saw to cover more than just the State Department. Another amendment that is in there is it also covers our local departments. Virginia is a state-supervised, locally administered system. What that means is the state actually does not do the contracting for foster care. That is done through each of our 120 local departments of social services. So in order for this to actually be in effect, it needs to apply to federal funding that comes out of us, if you want that tied to it, state funding, which is run through your Office of Children's Services, and through your local boards of social services, where the children are actually in the custody of the local board of social services. So those are several of the amendments that you're talking about to help clarify.
Can I have a follow-up, Madam Chair?
Delegate Trump.
Thank you. So I just want to make sure I understood two things that you just said. So there are no, in the foster care system, state and federal funds are always tied together. So are there any agencies that receive funds for foster care services that just receive state funds and just receive federal funds, and then the third bucket would be receives both?
Okay, Madam Chair and Delegate Trent, I'm going to answer your question in a couple of different ways because we're commingling several different conversations with this. For children that are in foster care, you can have children that are 100% federally funded, you can have children that are 100% state funded, or you can have children that are a combination of federal and state funds. For an agency such as Commonwealth Catholic Charities that Delegate Levine was talking about, those children are considered to be in therapeutic foster care or treatment foster care. Those children receive a combination of federal and state funding to pay for those and a local piece to it as well. So they get federal funds, they get state funds, and they get local funds. So you can't separate one of them out without talking about all three of them in conjunction. In addition, as a state, we actually do state contracting for adoption services and things along those lines with Commonwealth Catholic Charities as well. So we have state-only money that goes directly to that entity as well that is not directly tied to an individual child's placement. So when you're thinking about this, is you have to think about it very broadly about all the money that's being used and how it's being used with that specific agency.
Delegate Delaney.
Thank you, Madam Chair. I think my question will be for you, Mr. Ayers, but if we'll see. But many of you know I've worked with children in foster care, and there are a few things more heartbreaking than a child in a non-permanent placement that is desperately waiting for a loving home. My question about the implementation of this legislation, I need to better understand the population of children that we're discussing, the amount of money that is currently being allocated towards the child placing agencies function with those children, and what slice of the pie of that total funding is required for that care. How much of that are we providing as the state? And see if I can phrase this. I would imagine that a private child placing agency has a certain budget to deliver those services, and we are providing a portion of that complete budget. So if in implementation, if we were to pass this law, how many children, and I know the delegate mentioned this, but just to confirm, how many children would need to be replaced under the presumption that Catholic Charities or any other organization that might be caught up in this would need to be relocated to a different placement, and what would the funding implication be for that reallocation? Because the premise of that is my understanding would be that our state funds fund a portion of that operation that serves those children. And I just want to understand the actual implementation and the impact that would have on that caseload.
Yes, Madam Chair and Delegate Delaney, I will do my best to answer that. If we had somebody from private providers, they could probably do a better justice to it than I will, but I'll try to explain it as best I can. So any of the entities that we contract with that do a foster care service for the state, they do other services in addition to that. So when you look at the operating budget for that private provider, they will do a number of different services that are above and beyond just the foster care piece of it. So when you look at the portion of their operating budget, it would depend on the different entity as to what size of that it impacts. So as a private provider, and we'll just use Commonwealth Catholic Charities because that's the one we've been talking about, treatment foster care is only one portion of what they do. So they do a whole different milieu of services that are not treatment foster care, for which they do not serve that. The numbers that were provided to you, I believe I provided at Delegate Levine's request. I didn't see what he handed to you, but he made a request and I gave him the specific numbers on behalf of the Office of Children's Services and on behalf of my office. The numbers, yes, so this that was handed out to you, these are numbers I provided a delegate's request yesterday specific to Commonwealth Catholic Charities. I do not know every single provider that has a faith base that says, I'm going to approve this provider versus this provider, or I only approve this couple and that couple. So I would have to do a ton more research to be able to fully answer your question, because you're getting much broader than just one specific entity, and so I would need to really pull that together to answer your question more fully.
Delegate Delaney.
So I guess to be specific with these examples, and just to kind of use this as an example, in fiscal year 19, there were 59 children served by Commonwealth Catholic Charities. I'd like to understand the difference between if those 59 children were moved to a different organization, how much would that cost to manage? How much does it cost to manage 59 children's caseload versus what amount of state funding are we giving Commonwealth Catholic Charities to manage that caseload? I hope that's clear. There's 59 children. There's a cost to manage that caseload. We are providing what I believe is a portion of that cost. I want to understand how much is the difference, who's responsible for paying the difference, because what I'm concerned with is making sure that those 59 children at that organization, and I don't know the full scope of what we're looking at, I want to make sure that they are not displaced by any action that we take. That's what I want to ensure, and I want to understand the scope of that.
Sure, and Madam Chair and Delegate Delaney, a couple of things. So we pay a fee to the agency when they are in TFC, so we pay a higher rate to that entity. And so we pay for the overhead and the case management, those sort of things that we do not pay if we're in a local Department of Social Services. So I'll give you an example. So our average payment to a foster family inside of a local department is about $596. In a TFC agency, we're paying them approximately $3,000 to $4,000 per month. There is a significant difference. So we are paying that level of overhead to the TFC agency to provide that case management service and pay them a higher fee. That is included in those numbers. So when you ask about for fiscal year 19, there were 59 children that were placed with Commonwealth Catholic Charities that we paid a total of just shy of $1.3 million to that entity for those TFC services. So if you were to shift that to another agency that provides TFC services, you would basically be paying that same amount to another entity. The impact I cannot answer for you is I do not know what the impact that would be on Commonwealth Catholic Charities or their overall operations or what percentage that is of their budget. It's just, that's not a number that I would get into, so I don't know the impact. But the total cost would stay very similar. You would just be using another entity. To your last question, all of those children would have to be disrupted. And so that's I think the bigger conversation when you're asking that question. If we say, unless we add a grandfather clause or that this doesn't impact the children that currently exist, then where you're not making new placements, then the children that are currently there, whenever we say that, and that we cannot no longer use those funds, then those children would have to be moved. And they would have to be moved to another home, which disrupts permanency, and all those other pieces that you've heard other bills talking about we're trying to stop. And so that's the real impact if you do this, not only on future placements, but for the children that are currently there, they would have to be moved and relocated to another home. And you already also understand from the previous discussions with this committee over the years, we have a significant issue with a lack of appropriate foster homes for our children in Virginia to begin with. So we exacerbate that issue in the interim, especially for those children that are currently placed. And so I can't tell you the full impact as we go forward, but that's the impact on the current population as it exists.
Delegate Tran.
Thank you, Madam Chair. I think you might have answered my question in your response, sir, but I was going to ask, if you were shifting 59 children from this one organization, and it sounds like you haven't yet done a scan to see if any other organizations would be out of compliance with this bill if it passes, right? So there may or may not be additional children affected, but do your other organizations that you work with or the local agencies, do they have the capacity at this point to absorb these children? Because I don't see a delayed enactment, so this would go into effect in July. So would there be, is there that capacity? And then also, I think one of my original questions earlier was in lines 92, the substitute, when we're talking about any child placing agency, is that only are child placing agencies just in the foster care space, or do they also include other services that we can, such as working with homeless youth or other youth and things like that? If you could explain that too. Thank you.
Yes, so Madam Chair, Delegate Tran, so a couple of specific pieces is that any child placing agency, that actually includes your local departments or private licensed child placing agencies, and we're talking about in the foster care and adoption realm. So it goes from that piece of it. It would generally not hit homeless youth or anything along those lines, because in order for those placements to occur from a public entity, the child already has to be in the custody of the local Board of Social Services. So that gets into your funding and some of those other questions that you had earlier from that end of it. And can you help me with your first question again? I'm trying to make sure I answer that that correctly. And
Thank you.
Sure
So if these, understood that there are significant consequences to disruption, but if this bill were to pass and you now have 59 children that you have to place in a new home or situation, do your partner, other organizations that you work with or the local agencies, do they have the capacity at this point by July 1 to absorb 59 children in new homes?
And Madam Chair, Delegate Tran, to your point, each individual placement is an individual decision. So you can't just say, I've got 60 homes, so I've got 60 homes available and I'll move 60 children. Children that are in TFC already have a higher level of need than they do if they are in a local Department of Social Services home. And so all the other conversations you've heard about older children, about children with specific behavioral needs and those sort of things, that's what qualifies you to go into a treatment foster care level of placement. So we would have to look at each one of those individual children that are placed. We would have to look at their individual situation and try to match them with a new home that would be willing to take the child's behaviors and specific needs. Additionally, those children may be placed in as close to the biological family as they can be. And we have to do something that's called a best interest determination. And what that best interest determination says is that the child has to stay in their same school district that they came out of, unless it is determined in their best interest to switch their school. And so you've got multiple factors that go into that piece of it. So to fully answer your question, I would have to go through each one of those children that are placed, see if there is another home that would be able to do that piece of it, and then run through all those criteria that led to their original placement to determine whether or not we had capacity to do that. And that's the best answer I can give you right now without looking at each of those cases.
Madam Chair, we have a number of agencies in Virginia that are here and want to testify, and I think may be able to answer some of these questions. I'm not sure, for example, but I'll let them answer the question, whether or not we'd have to move a child from a home if the home was getting funding from Catholic Charities or the home would get funding from the Baptists, who don't discriminate. So I'm not so sure the child would have to move homes, but they're here and they can testify to answer some of these questions.
Thank you, Delegate Levine. Any in opposition to the legislation? Oh, did we not do 4? Oh, sorry. Any other questions of the committee? Those in favor of the legislation, please come forward.
Good morning, Madam Chair, members of the committee. I'm Claire Guthrie Gastanaga on behalf of the American Civil Liberties Union of Virginia. I have to say I'm much happier being here to support repeal of the so-called conscience clause for child placing agencies than I was in 2012 when I was trying to convince the General Assembly not to adopt this legislation in the first place. The ACLU is very sensitive obviously, to the important constitutional right of religious liberty, and we strongly advocate for the right of each person to practice his or her religion or not to worship, consistent with the demands of his or her own conscience. But this is not about that. And I really want you to try to change the way you have this framed in your minds as you hear what I have to say, because this is not about that. When a private organization, even a private religiously affiliated organization, performs a quintessentially government function, such as certifying adoptive parents or placing children with foster parents, it must do so in a non-discriminatory way, because the government couldn't discriminate if it was doing it directly. And what we've done is simply allow private agencies to do something the government could not do itself. Having chosen to act in the state's capacity, therefore, these agencies must be held to the same standard as if the state was performing the activities. Every adoption has to be approved by a circuit court judge, a state actor, and adoption is therefore a government function. Adoption agencies are the gatekeepers to this governmental process. They should not be permitted to close the gate on potential parents based on factors, or on potential kids who need to be adopted based on factors that are unrelated to the parent's ability to be a good parent, such as their marital status, their race, religion, sexual orientation, or gender identity, national origin, or disability. Moreover, most of the private child placing agencies licensed to perform adoption services are also licensed for foster care services, including the placement of children with foster parents. Again, this is quintessentially and unquestionably a government function. These kids are our kids. Kids that are in foster care are the state's children. The state's children. So state law should not enable policies or actions or fund agencies that use factors other than the best interest of our kids to limit the pool of foster parents available to those children who are in desperate need of forever homes, or to refuse to serve any child. The other piece of this is that the current law not only allows discrimination against prospective parents, but decisions not to provide services to the individual children, causing direct harm to them. Allowing agencies to make decisions regarding children in need of foster care or on any basis other than the child's best interest may result in a child losing a placement with the most suitable family. It's time we repeal the law and return to the time when our adoption and foster care agencies were held to one overarching standard, making decisions in the best interests of the children they serve. This legislation would do that by requiring any agency that wishes to perform these government functions to live up to the same legal and constitutional standards that the government itself would have to meet. Choosing to offer or to contract to offer what are services that would otherwise be government functions means choosing to comply with government rules. And child placing agencies that do not wish to do that should not be licensed or funded by any public agency. Thank you. I'd be happy to answer any questions. Okay. Thank you very much.
Thank you.
Madam Chair, members of the committee, Valerie LaRue from Virginia Poverty Law Center, and we also support this legislation. However, we share Delegate Delaney's concerns about the potential for children's lives to be disrupted, as you've heard from the Department of Social Services. Disrupting children's placement ultimately impacts their ability to gain permanency in their lives, which is one of the intents behind this bill, is to help children to gain permanency. So whether it's a grandfather for the children who are already in there, or if there is a directive to the Board of Social Services to not disrupt children's lives in the process of transitioning from the current state to the state that we would be under come July 1st, I don't know that it's important, and the department might know what the best way for it to proceed would be, but I would certainly ask that the children currently in care be protected under this change. But with that caveat, we support this bill. Thank you.
Good morning. I'm Rebecca Ricardo. I'm the Executive Director for C2 Adopt, a licensed child placing agency here in Richmond. I will make the distinction, though, we are one of the very few child placing agencies that do not do foster care. We only do adoption. But we support this because we really feel strongly that we are missing populations of people who would be able to come forward and meet the needs of the children in foster care. And as Mr. Ayers already mentioned, we are in a critical need for families. So to allow any child placing agency that's licensed by the Commonwealth of Virginia to be discriminatory in potentially eligible families that could be available for these kids just should not be happening. We're also very concerned about the children in care, and the ability to allow certain child placing agencies to potentially discriminate against children and not provide services to them is appalling to us as a child placing agency. So we support the repeal of the Conscience Clause, and in light of the conversation we've just had about the disruption potential for children that are in care with an agency that might have to stop serving, I just want to say this. First of all, I think a grandfather clause to give time for that would be appropriate. I think there's also some other workarounds we could do. The families of those children perhaps are not discriminatory and could be absorbed by another agency as becoming one of their families, so perhaps the child wouldn't have to move anywhere. But as Carl Ayers said, we would have to make that decision child by child. But there certainly are a lot of child placing agencies in the Commonwealth who do not discriminate. And I think, the money would transfer to them, so the money's the money, no matter where the child goes. And I think there are some workarounds that we could creatively do collaboratively amongst the child placing agencies and local departments to make sure that our children were harmed the least. But we need to remember we've got to go backwards to, we've got kids who are potentially sitting in foster care simply because an agency wants to be discriminatory about the family that's out there and available to them, but there's something about them they don't like, so they don't want to place with them. And that's not appropriate. It's certainly not appropriate use of public funds. I'd be happy to answer any questions if I can be helpful. Thank you.
Good morning, Madam Chair, members of the committee. My name is Dylan Wagasback, and I'm the Public Policy and External Affairs Director for True Colors United, which is a national nonprofit founded by Cindy Lauper to end homelessness among LGBTQ youth and youth of color. I'm also a national co-chair of the Every Child Deserves a Family campaign, which is a national campaign to end discrimination against LGBTQ children and families in child welfare systems. On behalf of both of those entities, we support the bill.
Good morning. My name is Mary Romiller. I am Policy Counsel with Family Equality, but I also live here in Virginia. And Family Equality spearheads the Every Child Deserves a Family campaign that Dylan just mentioned. It is a state and national campaign that is made up of child welfare organizations, faith organizations, and the civil rights community to act with the purpose of promoting the best interests of children in child welfare by increasing their access to placements. And we wholeheartedly support this bill. As we all know, that Virginia was the second state in the nation to pass this harmful law, and child welfare experts agree that discriminatory laws like this are bad for kids because you are reducing the number of homes available for children in care. Speaking specifically to Delegate Delaney's concerns and some of the concerns that came up, there is absolutely no evidence that a bill that repealing this law and passing this bill will result in fewer homes for children or harm children who are currently in placements. An example is recently in D.C. Catholic Charities left D.C. when they passed non-discriminatory protections. There were 40 kids in care. Those kids were all absorbed by another agency, did not miss a beat, and those who were placed in homes, there were no reports that they had to be placed in different homes. The homes that they were in simply transferred the case management to the new agency that took over. The homes did not say, we won't continue to take you. They were just managed by an agency that did not discriminate. In theory, if you had a discriminatory a family that refused to work with a non-discriminatory agency, that would be the only situation where that would come up, but I think that's very rare because most of the people who do this because they love the kids, and they're not going to turn away a kid. So I understand your concern and where it's coming from, but in practice, it has not been something that we've seen nationwide. So I hope that helps. I think I would also just like to say that in the states where non-discriminatory laws have been passed, we have not seen a mass exodus of agencies who are taking care of the kids. Most faith-based agencies do not discriminate, and we do not expect to see a mass exodus here. So, as I said, to those that do leave, those kids will be taken care of. They will not be abandoned and put back into congregate care or something like that. And in those states where the non-discriminatory laws have been passed, the states have found other ways to work cooperatively with the agencies so that those agencies are still very much involved in caring for children. They are just not doing the child placing function where they're able to turn away qualified homes for those kids in care. I think just in closing, I would just say that One thing to also keep in mind when looking at this bill is that if you look at the data, since this law was passed, there has not been, the number of kids waiting for adoptions has actually increased. And we're not saying it's because of this bill, because that's a causal relationship we can't say, but what we can say is that this bill is not having the promised effect of the initial law is not having the promised effect of getting these kids into more homes. So we need to try something different. This bill will allow for more placements to be opened up and help get Virginia off of number 49 of the list of the list of states. We're 49th in number of kids who age out of foster care, so we need to work on improving that, and this bill will help us do that. So we join our friends in the child welfare community and support this bill because it puts the kids first. Thank you.
Thank you. Thank you so much. If the next individuals just can say the name of the organization, because in order to go through a fair process, we would like also to listen to the other side of that issue. Thank you.
Certainly. Madam Chair, members of the committee, good morning. My name is V. Lamneck. I'm the Executive Director of Equality Virginia, and we support this bill for the reasons stated. Thank you.
All right, thank you. Is there anyone in opposition of this bill? So I do want to be fair in the process. So please, for the speakers behind the gentleman here up front, if you can provide to us different factual information so it's not repetitive, so we can move through this really quick. Thank you, sir.
Yes, thank you, Madam Chair and members of the subcommittee. My name is Jeff Caruso. I'm with the Virginia Catholic Conference. We're here in opposition to the bill. I'm going to be extremely brief because we do have providers as well as parents that can speak to this issue. I just want to, first of all, clarify, as you've heard before, the bill really does two things. The first thing it does is it repeals the existing conscience law. That's on line 101 of the substitute. That's the existing conscience law, and this substitute proposes to repeal that, which of course we oppose. And then the second thing it does is it addresses those, it takes away the ability for state funding for some organizations, and that's what you find on lines 92 through 100. Speaking more broadly to the bill, just three basic points. First point I would make is that we need more resources for children, not less, and we need to increase, not decrease, the opportunities they have to be placed with safe and loving families, and the community partners who will provide these opportunities. Secondly, birth parents should have choices. Some birth parents choose faith-based providers due to shared beliefs. That option should continue to be available to them. And then the third point I would make before I turn it over to other speakers would be that providers of various religious beliefs, a diverse array of religious beliefs, should have equal access and an equal chance to partner with the state. So with those remarks, I'd like to turn it over to those that can speak with more expertise about some of these issues.
Thank you, sir.
Madam Chair and members of the committee, my name is Jay Brown. I'm the Executive Director of Commonwealth Catholic Charities here in Richmond. Our mission is to provide quality and compassionate human services to all people, and especially the most vulnerable. We are one of the larger and more well-established nonprofits offering child placing services across the Commonwealth, and we partner directly with the Commonwealth and its localities to protect and nurture vulnerable kids. We serve close to 200 children each year in our foster care programs right in central, western, and far southwest Virginia. Currently, our census in our therapeutic or treatment foster care program is 81 children. We have an additional 43 in our unaccompanied refugee minor foster care program. Our outcomes are noteworthy. They're evidenced by a reduced number of disruptions and moves for our children, and the number of children who successfully meet their permanency goals, and the number of our foster families who adopt their children in their care. Our state contract to provide adoption services is restricted to several localities in far southwest Virginia. We feel a significant need in adoption in this area due to the lack of other nonprofit providers who are able to provide the service. In addition to providing treatment foster care, we contract directly with the Office of Newcomer Services, a division of the Department of Social Services, to provide foster care for foreign-born refugee children who present unique needs and challenges. And by accepting legal custody of these children, Commonwealth Catholic Charities assumes full responsibility for their care and their safety until they emancipate from our care. Our commitment to quality is evidenced by not just meeting state licensure standards, but also by meeting or surpassing third-party accreditation standards established by the Council of Accreditation. As a Catholic agency, we are guided by Catholic teaching in the provision of our services. It is our hope that we can continue to provide these valuable services and contribute immensely to the child welfare community across Virginia while adhering to our Catholic identity. At a time when there is a great need for placement and support services for children engaged in Virginia's child welfare system, we believe it's in the best interest of Virginia's children to increase the number and variety of providers available to serve them rather than exclude agencies based on their religious beliefs. Thank you for your time.
Thank you.
Thank you. Good morning, everyone.
Could you like to move the microphone in front of you down so we can listen
yes.
to you? Thank you.
I want to say something. I'm a little bit nervous. And then I just heard someone saying that CCC discriminates kids. It's not true. I am a gay. My foster parents were Christian. They are Christian, and they love me. And my foster mom, I still call her my mom because she loved me more than my biological family. And it's not true that they discriminate. It's not true. I'm sorry, but it's unfair how they are fighting to put a bill to place a bill in here saying that they discriminate, they this and they this, but it's not true. They have not been in the program. They have not been living our life. So it is not true that the program discriminates kids like us. I am used to be in foster care. Now I'm in college thanks to the program. They supported me mentally, emotionally, financially. They supported me with everything. I used not to accept who I am, but with talking with my social worker, talking with my mom, I got the support that I needed. Maybe the people who want to put a different bill in here, they just go scientifically, they just go on Google and Google shows a different data or based on this, they just go on basis. No, they have not heard anybody who was in the program. I have many friends who used to be in the program as well. I can mention them. Carlos Chicas. What is the other name of my friend? William. Those are my two best friends that used to be in the program, and we are gay. And then we never receive what they were saying, discrimination. Never. That is not true.
Thank you.
That is not true. I'm sorry. Thank you.
No, you're fine. Thank you. Next.
Good morning, everyone. My name is Mateo. I used to be in the foster care system back in 2012 until 2017. I was in the foster care for 5 years. First of all, I would like to explain that Catholic charities, when I got in this beautiful country, they become part of essential in my life. They become like part of my family, I could say. I would not be here today if Catholic charities, they would not have helped me out. I was 15 years old when I got in this country with no family, with nobody with open arms. But Catholic charities, they provide me a food, a place to stay, and a family where I can stay. Before meeting the Catholic charities, I did not have really, back in my country, and when I got here, I did not really have big expectations in my life. Never basic things like going back to school or just normally have like a normal childhood. Catholic Charities, they provide me like mentally, emotionally, spiritually, and physically. Catholic Charities has changed my life and made me a better person over the years. Catholic Charities have not only helped me, but also they help hundreds of kids. Last year, I was able to travel back to visit my family and travel back to my country. And I had the opportunity to go back in one of the schools that I went, was in a middle school when I was back in my country. I was able to share the values. I was able to share all the things that I have learned from this place, from Catholic Charities, all the value, the core values that really means a lot to some of the children. I was able to talk to like in front of like 150 kids back in Mexico. So I think it does not help, not just Catholic Charities. They have not only helped me, they have saved and helped a lot of kids back in everywhere around the world. I know and I believe that Catholic Charities provides and plays an important role in the modern society. When I was in foster care system, I never faced like a discrimination or anything like that. I was in the foster care system. I shared with many different cultures. Most of the kids that they were in the foster care system, they are my friends now. I know most of them, and none of them, far as I know, they have never faced discrimination or anything like that. I
Thank you,
support
sir.
that.
I think that you told us, I'm sorry, we have a huge line, and we just want to listen to everybody.
Of course.
Definitely, brought your point across. I just wanted you to know that nobody's doubting in this committee, and I speak on behalf of our committee, the impact of lives that Catholic Charities have been doing, not only in this country, but in the world.
Yes.
All right? So it's just that we have this piece of legislation and we had to talk about it, but I'm happy to hear that, someone like you has been welcome to these countries, living a happy life, and I thank the Catholic Charities as well.
Yes.
Thank
you.
sir.
Thank you for your
Thank
time.
you. All right. For the future speakers, if you are talking on behalf of organizations, if you could please, we are well aware of what you guys do. What we wanted to focus on is how this bill will impact your organization, and please be specific, be factual. I would appreciate that.
Sure, thank you. Madam Chair and members of the committee, good morning. Thank you for the opportunity to share. Thank you for the opportunity to share today on behalf of many children and families that we serve. I'm representing America World Adoption today. We're a faith-based agency that has served 1,500 families in Virginia, as well as 6,000 families throughout the U.S. in our 25-year history. And as a Christian agency, our efforts are deeply rooted in our biblical calling to care for orphans and widows. And we believe that Christian families greatly value and benefit from working with child-placing agencies who share a similar worldview and values. We desire to continue serving children in need and supporting the families who welcome them into their homes. While we do provide training and support to individuals of varying faith backgrounds, it is often a family's Christian religious conscience that has led them to the adoption process and who we speak on behalf of today. These families share an equal role as taxpayers and citizens and deserve to have an opportunity for their beliefs to be supported and the agencies that they choose to work with to be represented at a state level, funding level. And we appreciate your consideration and support as we continue to serve families in our efforts on behalf of the children that they care for. Thank you.
Thank you. Next. Remember, we have a lot of people waiting that have traveled from different places. I want to listen to everybody, but I just want everybody to be respectful of each other's times. Please tell me the name of your organization, how this bill is going to impact your organization more than anything.
Thank you, Madam Chair. My name is Megan Lane. I am the Director of Pregnancy and Adoption Support in Northern Virginia, which is a program of Catholic Charities Diocese of Arlington. This bill will impact the work that we do with families that we serve. We've talked a lot about the foster care impact, but we've lost the conversation in regards to other adoption services that fall under our license as a licensed child placing agency. We work with many birth parents who come to us in a crisis pregnancy who want to make an adoption plan for their child. And if they are coming to a faith-based organization, oftentimes they are driven by their faith to come to us. And these parents deserve counseling, quality, mental health, trauma-informed, ethical adoption counseling, which is something that we hold very true with my organization. We train others on how to do ethical adoption counseling when it comes to birth parent work. And that's a population that we've not talked about today. So I really want to bring that to the attention of the committee as well. In addition, adoptive families. My background is in foster care. I've worked in Virginia foster care, public and private, for 10 years now. There is a shortage of families who are able to take these kids. And oftentimes it is the faith communities that are the ones that rally around it. And we are asking to be a part of that because oftentimes our families are Catholic, because we are Catholic, or Christian, and they want to work with a similar valued organization. Our organization, at my program, we've served 4,400 individuals in the past 5 years. We've participated in over 100 adoptions just in our region alone, and that includes international, infant, foster care, and private adoption. And I also want to point out that we've done some special needs adoptions through local Virginia foster care adoption for kids that have significant medical needs. One of the families that adopted, they were turned away by some of the public organizations because they had too many birth children in the home. They came to us, we certified them. They're now parenting, adopted a 9-year-old little girl who spent the majority of her life in the foster care system awaiting an adoptive family. She has lifelong medical needs. She's nonverbal, like GI tube, wheelchair. So just to say that there is a place for these families, and we're not trying to impose our values on everyone. We just want to remain an option for some of these families and clients who still would like to work with a faith-based organization.
Thank you. I believe Delegate Tran has a question for you.
Yes.
Thank you. Thank you very much, Madam Chair. Thank you for being here today. Can you help me understand if a birth mother comes to you and wants to make an adoption plan for adoption services and such, are you receiving state funds to help provide those services to that birth mother?
No, we are not receiving any state funds for that, but we do it within the purview of our state-issued license, which is issued by the Department of Social Service. So the license is a component here, and it also covers our post-placement adoption work that we do. We've been doing adoption since 1947. We're a lifelong resource. If a woman does place her child, she will need access to counseling forever. Adoption is a lifelong journey, and we are always there and available we have support groups and counseling and everything for our adoptive clients. So
I know, Madam Chair, just one quick follow-up. I think our counsel just stepped down, but I think it would be helpful. No. And maybe if you're not able to make the ruling now, but does this substitute bill affect agencies such as this one who have a child placing license who are working on adoption services as well? It sounds like the license is issued by the state, but there are no state funds that are going towards the adoption services and post-placement services and such.
was that a question from me? Oh, okay, sorry.
There is no license provision in the bill whatsoever. Catholic Charities has been licensed since 1947, long before this clause came in 2012. It does not affect licensing. It does affect state funds.
Yeah. Thank you, ma'am. Our next speaker. Remember, name of organization. We know you all do an amazing job. Just tell us how this impacts your
I'm not an organization. I'm an adoptive mom. I adopted 3 boys, ages 10, 13, and 17. And I'm here basically to represent the parents who are actually on the ground loving these children. If you are a parent of biological children times the hardship by about 50 when you take a child coming from a place of neglect, abuse, and trauma. It changes the entire family structure. It affects every biological child in your family. It affects your marriage. It is a sacrifice and a commitment until the day we die. As a Christ follower, I needed a Christian agency that would stand with me, to walk with me through the intense, hard struggles of loving these children. However they were abused, they will abuse you. You need an agency that can pray with you, that can give you other families that are walking in the exact same place you are. I and my husband were compelled to adopt these 3 boys only because of my faith. Christ says true religion is caring for widows and orphans. I didn't do this to make my life easier, more pleasurable. I did it as an act of obedience. The Christian organization we partnered with is America World Adoption. I know at any given time I could call the person who started the agency and she would pray with me. She would support me. She'd say, let's go to lunch, cry. We need Christian organizations to be supported. As a parent, my energy, my love runs out. Done. I have to have a shepherd staff to walk up this hill with, and the Christian agencies and all the support they give me are that staff. If you kick that staff out from under us, we're not going to be able to step in and love these children and take them into our homes. 2/3 of all the children being adopted in America are from active Christian families. Thank you.
Thank you, ma'am. Yes, sir.
Madam Chair, Todd Gackey with the Family Foundation, just making a few points here. First, I want to start off with, throughout history, churches and faith-based organizations have led the way in taking care of orphans and children without parents. And so government has stepped in and has formed this public-private partnership. And I can't think of a more better or longer-serving public-private partnership than the Commonwealth of Virginia has had with private adoption agencies. For years, these agencies, more than half of which are faith-based, have provided services to families and children in Virginia, helping thousands of kids and have saved untold amounts of dollars. These faith-based agencies fill a need and a void that the state can't fill. They still have to meet the obligations. And under this bill, if they don't meet some type of contractual agreement, they could lose their funding. But however, I do want to point out to you that just last week, the Department of Health and Human Services announced its initiation of a rule that would ensure that faith-based agencies cannot be excluded from this funding. So, these are just efforts to punish faith-based adoption agencies because of their views on family. Is only going to decrease the number of children. And as we've seen with the JLARC study that came out recently, there have been efforts by this body to improve the foster care system. We just listened to a few bills regarding kinship care. There are efforts to improve this foster care system, the adoption process, and to eliminate faith-based organizations from this process is not going to help. You're going to take away well-qualified, loving families, loving parents from this process. I will close with this because I am a foster care father and adoptive. My wife and I have been in foster care for a number of years. We've adopted, and yes, we've gone through a faith-based organization. And the person that went before me described it perfectly because we are walking this journey together. We are compelled by our convictions to serve the young children, to provide loving homes. And these faith-based agencies help parents do that. So I would strongly recommend that this committee oppose this bill.
Yes, ma'am.
Hi, I'm Chelsea Ingersoll. My husband and I are also adoptive parents, and
I just want to echo everything that's been said. Our heart is to care for an orphan and have him in our home. And we know of many people before us who have adopted. And it is hard, and as you've mentioned, or as everyone has mentioned before me, it is hard, and we need that support. And my husband and I, as we were seeking out an adoption agency to walk with us in this lifelong process, we chose specifically America World because of their faith-based convictions. So thank you.
Thank you. Right, Delegate Levine, closing remarks.
Closing remarks. There are a number of good adoption agencies all around the country. There are a number of very, very good state-funded, faith-based Christian adoption agencies that can give all the support that is necessary, can give it in a faith-based context, but simply choose to allow all families in Virginia to adopt, serving the best interest of the child rather than the best interest of the agency. Catholic Charities does amazing work all around the world. A lot of it is federally funded. They will continue to exist. I have no doubt about that. America World doesn't take state funds. They aren't affected by this at all. They will continue to exist. All the faith-based organizations that don't take state funds are fine. The ones that do take state funds, you've heard these children give these very powerful stories. Their parents didn't discriminate against them. Would any of these adoptive parents throw away their child because they're getting money from Baptists rather than Catholics or Lutherans rather than another faith-based organization? I don't think so. I think they love their children. I think they'll keep their children. I think their children will stay in the same families. You heard from Ms. Roe Miller. When DC did this, families don't jettison their children. They'll keep their children. They'll get funding from a different organization. But at the end of the day, this is all about the best interest of the child. The foster care families can get money from different agencies, but more families will be available to adopt. We've heard time and time again there are too many kids in Virginia in the foster care system. There are all these families wanting to take care of these kids and put them in permanent homes. Let's have something that's about the best interest of the child, not the best interests of the agency. I thank you, everyone, for your time.
Thank you, Delegate Levine. This committee works in motions.
To
Delegate Delaney.
The bill. Let me first be very clear that I know, and I don't want to speak for my colleagues, but I think I can probably speak for my colleagues, that we strongly oppose discrimination. And as someone who's worked in child welfare, I'm incredibly grateful for your passion for these children and these families and for moving the Commonwealth in a direction that makes a clear stance that we oppose discrimination. I think the debate we're having today is not about that fundamental value that we share. It's about the duty of this committee to ensure that the policy we implement, that we fully understand its impact. And I hope we can figure this out. I have questions about how many children are in fact impacted, because we've heard from an organization today that said they've served 1,500. We have a document here that says 59 were served by Commonwealth Catholic Charities, and someone testified with a different figure. I'd like to see a scan of the contracts that the state has with these child placing agencies so that we can truly understand how many children are we talking about. And then I'd like to have some analysis before us that could show the impact that this legislation would have on any case management adjustments or alternative services that these children would need. I think this is a conversation we need to keep having. I'm not following this with a motion right now, Delegate Levine. I want to just state what I think I would need and what I think other members of this committee may need in order to make the best decision, because any policy we vote on this year is going to impact these families and this caseload as potentially this July. And I think that it is our duty to ensure that as we move towards a loving and inclusive Virginia, reflecting the values that we share, we are responsible for that, for those children. and we are responsible for their well-being. And there's some information that I need to ensure that we're making the right decision as we move in the right direction. So I don't know at this point what timeline we'd be able to have that by. And that's where I kind of leave it to the patron to advise.
I would be willing to pass this by for a week and try to get you that information, Delegate Delaney.
All right, then I make that motion.
All right. House Bill 1051 will be passed by the day and has been moved
You have to
and been
vote.
seconded. All those in favor would say aye.
Aye.
Those against it, Delegate Levine, we'll see you next week.
All right, thank you, Madam Chair. Thank you, members of the subcommittee. Thank you, everyone.
Delegate Ron.
Hey, thank you, Madam Chair. Thank you to the members of the subcommittee. This bill is really short, so hopefully I can get you all in and out so we can all go to caucus. So this is for HB 1410. This regards the restaurant meals program. So HB 1410 would direct the Department of Social Services to facilitate participation in the federal restaurant meals program of the Supplemental Nutrition Assistance Program, or SNAP. The bill will allow our elderly, disabled, and homeless Virginians, and I want to repeat that. This bill is limited in scope to the elderly, disabled, and homeless Virginians to use a portion of their SNAP benefits at participating restaurants. No restaurants or businesses would be forced to participate in the restaurant meals program. Their participation will be based on entirely opt-in basis. In other states with the same or similar programs, and this is a range from Arizona to Rhode Island, so take your ideological spectrum and you can find someone who's going to represent it. Businesses and restaurants were eager to opt in, open their doors to new customers, and to have access to a dedicated source of revenue. And so with that, Madam Chair and members of the committee, I would just kind of close here by just saying that people need access to warm meals so that they have a healthy, balanced diet and increased food security. And one of the issues we're dealing with is something as simple as someone going to a Wawa or going to a Sheetz and being able to get a hot sandwich instead of just a cold sandwich from the fridge. So, Madam Chair, with that, I'd be happy to answer questions.
Thank you, Delegate Roy. Do we have any questions for the patron, members of the committee? Being none, is there anyone in the audience who would like to speak in favor of this bill?
Good morning again, Madam Chair and members of the committee. My name is Dylan Wagasback, and I'm the Public Policy and External Affairs Director at True Colors United. As I said earlier, a national nonprofit founded by Cyndi Lauper to end homelessness among LGBTQ youth and youth of color. I'm excited to be here today to support House Bill 1410. True Colors United is working across the country to assist states in reforming social safety net programs to help them work better for vulnerable populations, including youth and young adults experiencing homelessness. Federal law provides these supports and services to youth experiencing homelessness, but the ability of these young people to access such benefits depends a lot on how states implement the programs. Youth and young adults experiencing homelessness are only explicitly allowed to use SNAP to buy hot restaurant or prepared meals in 9 states in the District of Columbia at this time. As the delegate mentioned, those are states that vary from Arizona to Oregon to Utah to West Virginia. There's no additional cost for the Commonwealth to join the program, and restaurants are not required to join. A restaurant would have to apply and be low cost and be approved. And they would typically complete an MOU with the state. Young adults who are homeless can find it difficult to use their EBT cards to purchase food because they often lack the basic necessities for food preparation, like cooking utensils, clean water, or a place to heat, cool, or store food. Like so many people who live below the federal poverty line, people without homes often live in areas that don't have grocery stores, or if there are grocery stores, they don't have a place to leave their belongings while they shop. I can sort of read the room, and I know that folks are anxious to get out of here, so I'll close there and just offer to answer any questions if there are any. Thank you.
Thank you. Next speaker.
Good morning, Madam Chair and members of the subcommittee. I want to thank Delegate Rome for a wonderful bill. There are so many things in this world that we cannot do availing the state and the populations of the homeless, the elderly, and the disabled is something we can do through opening the restaurant meals program for them. I urge the subcommittee members to vote for this bill. Thanks.
Madam,
Unless there's anyone who's opposed, I don't think.
is there anyone in opposition of this bill?
Anyone doesn't like So, Madam Chair, I just want to note that I passed out the fiscal impact statement. What you're going to notice when you read that is that at the end it says, however, these funds can be absorbed within current funding levels and appropriation. So basically what we're talking about here is that basically the Department of Social Services can already just absorb the cost on it.
Madam Chair. Delegate Air.
I know you can't, question for the patron.
Yeah.
I know you can't sort of police this, but I want to make sure I'm interpreting this correctly. So this would allow like your fast food chains or anything classified as hot food be able to qualify if they are accepted into the program. So is there an instance where someone could spend all of their allotted supplement on like McDonald's?
Madam Chair, members of the subcommittee, I would defer to Department of Social Services on a case-by-case basis of this, but what I would just say ancillary to that is that in these states where we already see this already happening, typically you have, restaurants like Subway that are participating, right? Or you'll see Domino's or whoever it is. And so one of the things that we try to really make kind of clear with this is that it's not going to be our job as legislators really to more or less tell people this is how much you have to eat or where you're supposed to eat. It just simply makes hot meals available to them. And, one of the things I think that we're trying to do here is we're really trying to address food insecurity, whereas it's not really our job to judge Virginians in their need to survive, especially if they're in a food desert and especially if they're working late, grocery store is closed, and they want to pick up a hot meal.
No, of course not. I am not, and I don't mean any harm to your bill. I certainly understand the sensitivity of having access to food. I just I'm less familiar with this in other states, and so I was just trying to understand if that possibility exists.
Sure. I would defer to someone from DSS on that question.
Madam Chair, Delegate Air, Duke Storen, Commissioner of the Department of Social Services. So the federal government, the U.S. Department of Agriculture, would be responsible for approving the restaurant meal providers, and it would be possible for someone to redeem their entire monthly allotment by purchasing meals at approved restaurants. So that possibility does exist, and I think in the case of someone who is homeless, it would be an appropriate use of those funds because they have nowhere to prepare their food. So, but we, as the state, would not manage the approval of the restaurants.
Thank you, Commissioner.
Delegate Walker. Are there any more questions for the patron?
Second.
All right. Delegate.
Madam Chair, speaking to the motion, given the fact that that DSS is able to absorb the cost according to the FISC, is it appropriate for us to refer to appropriations in that case, or can the bill just simply move forward?
So what happened, Delegate Roem, is that we got a letter from appropriations, and we're going to have to refer it there. But, I would tell you that it's a great cause. I actually have a couple of individuals that visited my offices yesterday, and they were homeless individuals, and they told me how much their lives would be improved with your bill. So I want to thank you for bringing that forward.
Thank you, Madam Chair.
So House Bill 1440 has been reported and referred to appropriations. Clerk, open the rolls. The bill has been reported and referred to appropriations 5 to 1 vote. Thank you, Delegate Roem. Delegate Adams.
Thank you, Madam Chairman. And if it please the chairman and the committee, I have a suggestion perhaps with regard to this bill, House Bill 1025. I know that you've had a busy docket today and some bills had to been passed by, and I am likewise amenable to the bill passing by, but as I told your counsel, I do have a constituent who has traveled and would like to speak. He's sort of the genesis of the bill, and if you would indulge me that privilege, I would appreciate it if he could speak just briefly and maybe just to plant the seed in your mind about this legislation, because to him it is very important. And I have several other people who wish to speak, but they are representatives of law enforcement who are here routinely, and I'm sure they wouldn't mind coming back another day because everyone's got to be somewhere, and I don't think justice can be done to the legislation in this tiny period of time. But if you could indulge him just a few minutes, I think it would be a good testimony to hear, just to store away for consideration another time.
Absolutely. So first, we have a motion for the bill to be passed by the patron. Second, all those in favor would say aye. Right, bill has been passed. We definitely want to listen to your constituent, Delegate Adams. We want to encourage people to participate in this process, so we'll be more than happy to listen to him.
Well, thank you so much. And just by way of preface, and I ask that he step forward now. Oh, there he is. This is Deck Hardy. He's a former state trooper who was disabled in the line of duty, and he presented me with his experience, and that is the genesis for this bill, which asks that vocational rehab, a specific program dedicated to law enforcement, be established in that article of the code under the aging and rehab section. And so if he could just speak to you a little bit. Thank you.
Good morning, Madam Chair, members of the committee. As Delegate Adams said, my name is Deck Hardy. I'm a former trooper who is currently on long-term disability retirement with the state police. 5 years ago, or 5.5 years ago in July, I suffered a motor vehicle crash while on duty, and spent the last several years trying to recover from that. And unfortunately, this past fall of 2018, realized I was unable to continue as a trooper and had to take the steps to go through the retirement. The bill and program that Delegate Adams is introducing would do something that really would have saved myself and my family from the turmoil and heartache that we went through for several months in trying to figure out what are we going to do next. We thought our life was going to be this for the next 30 years. What do we do? Where do we go? How do I take the skills that I had and use them somewhere else? How do I take the certifications that I earned and use them somewhere else? So after much, I guess, inner debate in myself and not knowing where else to go but in myself, I did come up with a plan and have moved on to secure another way of life to provide for myself and my family. In the spirit of brevity, I will leave you with this analogy. In the current state of affairs, without the bill that Delegate Adams is presenting, a law enforcement officer that gets hurt in the line of duty gets taken basically like a old, rusted, dull, broken tool and thrown in the back of the shed. And there they have to fend for themselves and figure out what to do. The program that is in Mr. Adams' bill will take that tool and clean it up, add some WD-40 to it if it's rusted to help it work a little better, sharpen any blades that it is so that it can do the job that it needs to do. While it may not do the job that it was doing before, it is doing something else to continue being productive. And us as law enforcement officers are type A personalities. We want to give 100% to everything that we have and everything that we do. And when we can't do that, it really, we don't like to sit around and just sit back and wait for things to happen. So it really can send you into depression and can cause anxiety and can cause a whole lot of other mental health problems that could be erased by a program such as what Mr. Adams is presenting, so that they can find that other job and get cleaned up and be a tool somewhere else. Thank you very much.
Thank you, sir. Just a couple of follow-up questions. If you can tell me which county do you live and what is the agency that you contact first during this process? When you had this situation, what was the process? Which agency did you contact? and what happened?
I'm trying to see if I understand your question. I was a trooper in Pennsylvania County.
Yes, okay.
I live in Franklin County.
Live in Franklin County, okay.
And there was the only person or agency or anyone I reached out to was Delegate Adams and a couple of the delegates in my district. I think she means at the time of your injury. I'm sorry. At the time of my injury, I was basically unconscious for so many days. So whoever the state uses as their workman's comp program are the ones that took care of me during that time. Then through the VRS, I went through the READ group in order to have my long-term disability retirement.
Thank you. That's important because for next week we'll reach out to those agencies and find out what happened. So thank you. I appreciate that.
Yes, ma'am. Thank you.
Thank you, Delegate Adams.
Thank you very much. Look forward to another notification.
Yes, we'll see next week. And now we have Delegate Tran. Let me see.
Thank you, Madam Chair. I know last is certainly not least, but we are out of time as well. And so what I'd like to do is similar to Delegate Adams. I do have speakers who've traveled quite far to come and share their experiences with you in support of HB 1209, which would establish the Office of New Americans. And if they could speak and share their perspectives. I've also handed out letters of support from organizations here in Virginia and across the country that are working with other offices of New Americans to members of the subcommittee, so you have those in hand. But after we hear from my speakers, what I'd like to do is then pass by until next week and present the bill then to you all.
Sure. So what we do is we first do the motion to pass by. So move. So it's been moved and seconded. All those in favor to pass by House Bill 1209 for next week would say aye. Aye. Those against it? Being none, please bring forward the people that have traveled here. And thank you for being patient. It's been a long morning. I appreciate it.
It was very interesting to learn about the process.
Thank you.
Thank you, Madam Chair, as well as Delegate Tran. I'm here in support of HB 1209. I'm Susanna Lepley from Refugee Resettlement. I'm the Virginia Director, and I definitely am supporting this bill. Refugees, I'm skipping down my list of things to say. In 2015 alone, nearly 87,000 refugees living in the Commonwealth paid over $964 million in national, state, and local taxes, and held $2.5 billion in spending power. We have many success stories. I wasn't able to bring somebody with me today, but I wanted to share the story of Nasser al-Sadoun, an Iraqi refugee who originally fled to Syria in 2016 after his father was kidnapped and assassinated. He came to the United States in 2008, and since then he received his master's degree in education from Eastern Mennonite University. He has founded the American Refugee Association to help resettle refugees, as well as he is an active refugee leader in the community and is president of Harrisonburg's Iraqi Community Council. Is there anything else you want me to touch on? Thank you very much for your support of this bill. And on behalf of Church World Service and myself, please pass the bill, and also know that it will enhance immigrant and refugee self-sufficiency and contribute to the economy of the Commonwealth. Thank you for the opportunity to submit this statement.
Thank you.
Good morning, Madam Chair, members of the committee. My name is Justin Gandy. I am the site manager of the International Rescue Committee in Richmond. The IRC is a nonprofit that works with newly arrived refugees in the broader immigrant community in our state, with a second office in Charlottesville as well. I'm here today to express my support for House Bill 1209, Office of New Americans. Every day, I see firsthand the many contributions immigrants make to our community, from the businesses they open, to the vacant jobs they fill in various industries such as hospitality, warehousing, healthcare, into the homes that they eventually purchase and planting firm roots as Virginians. Immigrants contribute significantly to Virginia's economy, and so we must ensure that programs are in place to support these new Americans as an investment so that they can reach their full potential and continue to contribute to our shared prosperity. We anticipate that this bill would allow the service agencies to expand the programs offered to the immigrant community that are not federally funded, including immigration legal services. We would also be able to expand our employment, career development, and financial capability services as well. Regardless of where you're originally from, we have all chosen to make Virginia our home. We know that our state is a wonderful, welcoming place to live, and that immigrants have always been a part of our story and our success. I ask that you vote in favor of House Bill 1209 and embrace the opportunity to ensure that our newest American neighbors have the support that they need. Thank you.
Thank you, sir.
Madam Chair, members of the committee, Ben Hoyne with the Virginia Interfaith Center for Public Policy, representing tens of thousands of people of faith from across the Commonwealth. We support this legislation. As people of faith, we know that it's critical that Virginia welcome immigrants from across the globe. My family immigrated here hundreds of years ago, as I'm sure some of yours did as well. So we know that immigrants really make the Commonwealth a better place. So we encourage you all to support this, and people of faith across the Commonwealth are in support of this bill. Thank you.
Thank you, Madam Chair.
Just to be fair in the process, is there anyone here that traveled that is in opposition of this bill that would like to voice their concerns? Being none, thank you, Delegate Tran. We will need a motion to. Yeah, we already voted on. Oh, we have one more request.
Madam Chair, I have a substitute motion for this bill.
Sure, Delegate Aird.
First, I believe it has a substitute.
Delegate Aird, it does. We are working with our council to tighten up the language just around the advisory board piece of the bill.
If it's okay, I'd like to adopt the substitute.
All right. All those in favor to take on the substitute would say aye. Delegate Tran, in sake of time, could you walk us really quick through the substitute, please?
Yes, ma'am. So for the sake of time, so the substitute moves the Office of New Americans Advisory Board to a new section of the code and aligns kind of the membership, the terms, the compensation expenses, and some of the duties to be more similar with and to parallel other advisory boards that are currently in existence so that they kind of are the same, shape and form. Before we didn't have as much meat behind the advisory board piece of it.
So this bill, since will be a new office, it will have to be referred to appropriations.
It does. We do have a FIS, Madam Chair.
All right. So we are 2 weeks away from crossover. This committee works in motions.
Madam Chair, I move to report and refer House Bill 1209 to appropriations.
All right. This bill has been properly moved and seconded to be reported and referred to appropriations with a substitute motion. Clerk, open the rolls. Members, please cast your vote. Sure. This bill has been reported and referred to appropriations 6-0. Delegate Delaney.
Thank you, Madam Chair. I have HB 809, which I think will be really brief. Let's get us out of here. I hope everyone appreciates what we're doing here. There is a substitute being distributed.
So moved.
If Council, would you care to report the substitute when you were rushing along here?
The substitute makes a set of changes in 3 separate places. The first change is on line, I drew the substitute. One moment.
You want my copy?
I got to get the bill itself. Okay. The first set of changes, line 15, after the new language caretaker, it inserts parent's intimate partner, and then it takes out all of the other new language in that subdivision there. So it strikes the new language on lines 15 through 16 and the new language on 16 through 17. We make that set of changes in 3 places. Right there at the definition we talked about, similar changes are made on lines 48, 49, and 50. And then also towards the end of the bill on lines 52 through 352 through 354. So that the new definition, as you see in the substitute, says an abused or neglected child means any child less than 18 years of age whose parents, relative by blood, marriage, or adoption, caretaker, parent's intimate partner, or other person responsible for his care, etc.
Madam Chair, I move the amendment in the nature of a substitute.
All right, the amendment has been moved in a substitute form and properly seconded. All those in favor would say aye.
Aye.
Those against it? All right, Delegate Delaney.
Thank you, Madam Chair, members of the committee. I'll stay in my seat for brevity. So the purpose of this bill is when the Code of Virginia was written, the way we described a caretaker and a family, I mean, it looked a lot different than reality. And what we've seen now, in 2020, and looking back in the past fiscal year, there were 8,260 reports of abuse and neglect that DSS was not able to actually investigate because of the way we define how we define family member and caretaker. And so we are updating the language to have a better scope to capture the individuals that council just listed that would be open to now having that type of investigation. Now, the 8,260 cases, that would actually be a much more broad definition that I had an original bill to do. After looking at what the fiscal impact for that would be, we thought it would be advisable to start with where we are now with this substitute of expanding this definition enough to capture, I think, the most reasonable change. So with this change, we would see an additional 1,257 cases would have been able to be investigated. And so these are real-life families, as they are in Virginia this year, that when DSS comes, they are not able to investigate because of the way that we define these parents and caregivers. So this is a bill that I believe does have a fiscal impact, so I believe it would need, if the committee agrees with the concept of what we're trying to do is to better capture a family and the makeup of those caregivers who would be needed to be investigated if a report of abuse or neglect came to DSS, there would be a fiscal impact and it would need to be reported to appropriations.
So, Delegate Delaney, since first, thank you for bringing this bill forward. There's definitely this group of children that were just not being addressed through the system, and I want to thank you for that. At this point, we are waiting to hear back from that agency and from appropriations to see what is going to be their recommendation. So if we are going to pass by this bill until next, for full committee. So then in full committee, we'll go into full committee and we will decide then when we have the information before us.
Okay, I'd be happy if we got it to full committee.
Thank you.
Motion to move to full committee.
Okay. So what we'll do at this point, just so we have the information before us, before we cast our votes and we can all make an informed decision, I will just bring this bill forward to full committee and we can cast our votes then. All right. Thank you, members of that committee. Do I have a motion to be adjourned? Thank you. This meeting is adjourned.